Good afternoon, students. Already we have discussed about legal aid concept and need, who seeks legal aid, legal schemes and problems. But today again we repeat these things, and that will be followed by a note which will be given to you in the WhatsApp group. Okay? So how are you all? Enjoy the curfew period and help your parents also study. Now, what is legal aid? We have already discussed what the legal aid means. Legal aid denotes legal assistance to the poor persons, free of cost, in any judicial proceedings before the court or tribunal. I repeat, legal aid denotes legal assistance to poor persons, free of cost, in any judicial proceedings before the court or tribunal. It is provided to those poor people who are not in a position to enforce their legal rights or are involved by others in court cases. They may be involved by others in court cases, these poor people, and these poor people having no alternative to legal recourses may have to face a lot of problems just to provide relief to the poor sections of the people so that they can avail easily the legal aid. Certain provisions of legal aid are made by our constitution and by some laws. The meaning and objects of the legal aid, as I have already discussed these things before you, has been clearly explained by Justice P.N. Bhagavati, and he was then a Supreme Court, a judge of the Supreme Court. And according to him, legal aid means providing an arrangement in the society so that the machinery of administration of justice becomes easily accessible and is not out of reach of those who have to resort to it for enforcement of rights given to them by law. Law gives us certain rights, but they are unable to go to the court. They cannot access the legal system because of their pecuniary conditions. Therefore, through the system of legal aid, the machinery of administration of justice has become easily accessible and is not out of reach of those people who have to resort to it for enforcement of rights given to them by law. Poor and the illiterate should be able to approach the courts, and their ignorance and poverty shall not be an impediment in the way of their obtaining justice from the courts. It is the observation made by P.N. Bhagavati. There must be legal aid, and their poverty must not be an impediment for getting access to the courts. So, for obtaining justice. So, there are certain provisions for the legal aid for the poor people. The rule of law plays an important role in administration of the country. You know, the right to equality has been provided, and in every sphere that our citizens are not exploited, or citizens are not in a position, if they are not in a position to enjoy their rights given by the Constitution, the rule of law prevails. And we will discuss about these things under Article 226 of the Indian Constitution. They can approach the Supreme Court and the High Court. The rule of law plays an important role in administration of the country. The rule of law is regarded as the part of the basic structure of the Constitution and also of natural justice. Therefore, free legal aid has been held to the necessary adjustment to the rule of law. The Supreme Court in Hussain-Ara Khatun's case, in the year 1979, which was decided actually on the 9th of March 1979, held that the right to free legal service is clearly an essential ingredient of reasonable, fair and just procedures for a person accused of an offence, and it must be held implicit in the guarantee of Article 21 of the Constitution, and the state is under a constitutional mandate to provide a lawyer to the accused person. So, I request you to go through the book of Durga Das Bose and study thoroughly the Article 21, which actually gives a constitutional mandate to provide a lawyer to an accused person, and if a poor person needs some legal aid, he can even approach the administrative machinery. So students, by now you must be having the concept of, you must be having a fair idea regarding the concept of free legal aid. The Supreme Court, however, observed that this court declared the right of legal aid as a fundamental right of accused person by a procedure of judicial construction of Article 21. So fundamental, it has been declared as the fundamental right of an accused person by a procedure of judicial construction of Article 21. But the Supreme Court regrets the very fact that most of the states in the country have not taken note of this decision and provided free legal service to a person accused of an offence. That means the state have failed in some cases to provide free legal services to a person accused of an offence, even of the poor persons. It further observed that it regrets the disregards of the decision of the highest court. The highest court, it is a decision of the highest court, and the states have shown disregard. Therefore, the Supreme Court has expressed certain concerns for that, and they have said that the court has said that, Supreme Court, that it regrets disregards of the decision of the highest court of the land by many of the states, despite the constitutional declaration in Article 141 of the Constitution that law declared by the court shall be binding throughout the territory of India. So, Supreme Court, under the judicial construction of the Article 21, made the right of the accused as a fundamental right to go to the court. And under Article 41, the Constitution declared that this court, the order of the Supreme Court shall be binding, or law declared constitutional by the Supreme Court shall be binding throughout the territory of India. That means we have one constitution, and the Supreme Court being at the apex of the judicial system, its decisions or its not policies, its judgments given from time to time must be binding actually throughout the territory of India.